Hello guys, let's begin. So I will start from here in today's video. Let's see. Law against child marriage in India. Law can be the catalyst for social change. I guess you know what catalyst as a term means it can be termed as something which would speed up the process of bringing about a reform or a change in the society. That is basically what we call as social change. So to speed up the process of social change or to bring about a reform in the society, to change some ill or evil practices prevalent in the society, and for that we can use laws, because if we will make laws, then it will happen that those practices will not be continued in future. They will not be practiced in the coming time, and also that people will not obey it. And if I say it is a rule and regulation that you have to obey, so the people, and if you are violating that, you will get a punishment. So people will get a fear in their minds that now this is a part of a rule or a law, and if I'm gonna violate it, then I will be subject to a suitable punishment that was decided along with the legislation. So laws can be a thing which would speed up the process. That is, it can act as a catalyst for bringing about a social change. There were a number of Indian legislators in Central Legislative Assembly under British rule who fought to make a law preventing child marriage. There were, basically it is कि हमारी situation हम ही समझ पाएंगे, that kind of concept. Whatever the Indians or the Indian people in the society of the British era were getting into, or whatever they were tolerating, whatever they were subject to, whatever ill practices that were prevalent, because of which the plight of children or women was so poor or deteriorating situation. So if we are tolerating the situation, then we will only know that what kind of thing we are गोइंग ऑन फ्रॉम, राइट. हम किस चीज़ से गुज़र रहे हैं, क्या चीज़ हम सह रहे हैं, वो हमें ही पता हो सकता है. और उसको सही करने के लिए सबसे बेस्ट डिसीजन या लॉ हम खुद ही फ्रेम कर सकते हैं, ठीक है, क्योंकि हम पर वो चीज़ बीती है. तो इंडियंस, देयर वर नंबर ऑफ इंडियंस इन द लेजिस्लेटिव असेंबली in the British era in India, and those Indians said, and their main aim was to make a legislation so that child marriage can be abolished. In 1929, the Child Marriage Restraint Act was passed without the kind of bitter debates and struggles that earlier laws had seen. So in 1929 we had the Child Marriage Restraint Act that was still when the Britishers were ruling over India. And see, there were various brutal or bitter debates that happened for earlier legislations to be passed in the Legislative Assembly under British rule, but this one was passed along with the agreement of both the sides, and there was not so bitter debate or discussion that happened while this law was in the process. According to this, no man below the age of 18 and women below the age of 16 could marry. So what was the act? It said it prevented the child marriage, and they considered children to be a male who is less than 18 years age and a female less than 16 years of age. They considered them to be child. And now today's scenario, what it is, that whether it is a male or a female, 18 years below age is considered to be a child, and 18 or 18 plus male or female is considered to be an adult person. This is what today's scenario is like. And also there are considerations being made, or I don't know whether the development is going on in this area or not, but there were discussions that the age limit of a marriage for man is 21 years, and women also it would be extended to 21 years from 18 years. Okay, then, and now since we were doing that Lord Cornwallis introduced some sort of judicial reforms and policing reforms so that the law and order situation, there should be harmony and peace in the society or in the presidencies where the Britishers, and even where the Britishers weren't ruling. So for that he combined some religious texts or different kind of cultural or traditional texts or codes that were prevalent at that time, and made a Cornwallis code of his own that was completed by 1793. That all we have done in the previous video so far. Now, despite the best intentions, the Cornwallis reforms resulted in institutionalizing discrimination through judicial reforms. One consequence of Cornwallis Code was that it in effect institutionalized a discrimination against natives in the legal system. In 1791, Lord Cornwallis issued an order that no person, the son of a native Indian, shall henceforward be appointed by this code to employment in civil, military, or marine service of the company. Now, the main consequence, he had the intention that there would be a sort of harmony and peace and public order would be maintained in the society through my harmonized code of Cornwallis Code, but that was not the actual scenario that happened. The main consequence was that it created a sort of discrimination among the native people which were living over there, the Indians, and between the Britishers. Also, in 1791, Lord Cornwallis, he only issued an order that now onwards no Indian person, that means son of a native Indian, जो Indian resident है वहाँ के, उसका कोई भी बेटा वो भी एक native Indian ही होगा. So no native Indian, indirectly ये बोलना चाह रहे थे, no native Indian would be from now onwards given any job opportunity, or he will not be employed in any civil, military, or marine service of the company. These policies led to development of an elite class of English judges in India. Now, since there were no more Indian judges in Indian courts, the courts that were established for Indian society, there were no Indian judges sitting over there. There was no employment of Indians in the civil, military, or marine sectors of the company. So there were only English judges who were sitting over there. And now you see that there was a sort of discrimination. So we say that there had an elite class of English judges. English judges were appointed to various courts in India, including the High Courts and Federal Court, until India became a republic in 1950. Obviously, when it became independent in 1947, and later on when India became a republic in the year 1950, from there onwards, there were no more English judges to be appointed in the courts of India, only Indian judges were. Have you understood? So there was a sort of discrimination wherein there were no job opportunities available for the Indian native people, and there were only English judges that were appointed to various level courts that were established in India in various timelines, and so there was a sort of institutionalizing a discrimination. Okay, the crown courts in India operated on basis of law or equity and rule of good conscience. So the crown courts, we did what crown courts were. The crown courts that were in India, their main principle was that we will obey the law, whatever laws are there, and I have told you law basically was the English law. In the legislations which were in force in England, or the legislations which were passed by the British Parliament at that time, so whatever their own personal laws were, they used to apply that for Indians and over Indians, right? And there was, according to them, they ruled or they operated, they gave justice on the basis of equality and good conscience. According To Lord Hobhouse, the expression justice, equity, and good conscience could be interpreted to mean the rules of English law if found suitable to Indian society and circumstances. So, you see over here the same thing is mentioned, that to provide justice, equality and good conscience will be seen, and the English rules or the English law principles will be applied as far as it is found suitable in the circumstance or in the arena of Indian society and Indian people. But exact scope and meaning of this phrase was not and is not easily ascertainable, particularly because it also carried a historical background. Within the presidency towns, the English law was the lex loci. Now, this is a legal maxim, lex loci, which means law of the place, means wherever you are living. In whichever country you are living at the moment, the laws or the legislations of that country will be applied upon you. Like if you are living in India currently, so whichever rules or regulations or whichever legislations are in place in India, those all are gonna be applying on you. And if you go to England, so the England laws will apply on you because you are now on the land of England, right? So there, whatever laws are in existence at that time, those all will be applied on you. Law of the land, lex loci. So, whatever they found that if it is suitable, then we will apply the English law to Indian society, Indian people, and their situations or their problems as well, to administer justice, and that would be done on the basis of equality and good conscience. Also, the exact scope, this was, see, as I say, or as people say, that whatever you mention in the official documents or whatever is on paper, that same is not the case that happens in actual life, right? So you maintain a register of Mission Shakti, that is for women empowerment, for the protection of women from the evil practices that go on then and now in the society, from the you can say the eve feasting और ये सब जो छेड़खानी और जो भी विमेन के अगेंस्ट क्राइम्स होते हैं उनसे उनकी प्रोटेक्शन के लिए वी हैव मिशन शक्ति एज अ sort of mission or as a scheme to protect and to empower the women of the country or of a particular state, I guess, of UP. That's the scheme jurist limits to. But what it is that you maintain the registers, you say that we did this, we held this seminar, we held this workshop, and we made so many placards, and we revolved around the streets of the city, of the state, to create awareness about the same. But still, are the crimes on hold? Are there no crimes that are going on in today's date against women? Because I'm talking particularly about women context over here, so let me limit to that example only. So that's not the case. You are mentioning in your registers, in your official documents, that you are doing this or that for the empowerment, for protection of women, but then too, without any stringent, rough, brutal, bitter laws or legislations in place, the situation is not gonna improve. You need to be little bit strict with the people who commit crime if you want to improve, if you really want to improve the situation rather. So you maintain the things on paper, but the actual, if you see in the actual or real life, there is not the same scenario as you may want or as you may have noted down in your papers, right? So the actual life and your documentary life is very much different from each other. That's why whatever they had planned to do, now come back to the context of the book that we are reading right now. So if whatever they have maintained in their own books, whatever they have maintained in their thoughts, that we will do this and that, this way or that way, but that was not the actual scenario in place at that time also. They thought we will place the English law, and that will be suitable for various circumstances or for various principles or situations of the Indian people, for the Indian society. But then too, it wasn't the case. In presidency towns, obviously, where the Britishers were ruling, see, इंग्लिश लॉ बेसिकली हर जगह ही इंग्लिश लॉ वो अप्लाई करते थे, क्योंकि एज आई से तब इंडिया का कोई भी पर्टिकुलर और यूनिफॉर्म रूल बुक नहीं थी. जो वेरियस कल्चर ट्रेडिशंस थे डिपेंडिंग अपॉन वेरियस रिलीजियंस और वेरियस रिलीजियस बुक्स और टेक्स्ट, उन्हीं को एज अ रूल ट्रीट किया जाता था और कल्चर और ट्रेडिशन को ही बहुत ही लाइक सुप्रीम माना जाता था. राइट, दैट वाज द केस इन एंशिएंट सोसाइटी. So there was no uniform rule of India at place at that time. So they used to apply English law only basically. और अगर वो प्रेसिडेंसी टाउन्स हैं लाइक दोज 3 प्रेसिडेंसी टाउन्स कैलकटा, मद्रास एंड बॉम्बे, तो वहाँ पर तो इंग्लिश लॉ वॉज द लेक्स लोकाई. प्लेस भले ही इंडिया की थी, लेकिन कौन सा लॉ लगता था? ब्रिटिशर्स का. The only exception being for Hindus and Mohammedans who were allowed the benefit of their personal laws in certain spheres. So, as we know, Hindus, Mohammedans, they have their own religious texts or books, they have their own cultural traditions that they used to consider supreme, and they, on various certain spheres, they were allowed to follow their own rules, their own laws that their religion asked them to. Okay, so that they were also excluded in some certain arenas. They were not excluded that okay, you are completely free to follow your own. No, not that was the case. In certain spheres, in certain arenas, in certain topics, you were free to follow your own personal laws. Personal law means whatever the religion said. And what were those certain spheres? What were those certain spheres? Succession, inheritance, marriage, caste, all these. जो भी वेरियस संस्कार नहीं होते हैं कि जो भी बर्थ टाइम जो सेरेमनीज़ होती हैं या जो डेथ में जो सेरेमनीज़ होती हैं, वेरियस सेरेमनीज़, मैरिज सेरेमनीज़, उसमें आप अपने रिलीजन के हिसाब से जो भी आपका रिलीजन बोलता है उस हिसाब से आप उसको फॉलो कर सकते हैं. लेकिन अदरवाइज़ आप पर कौन सा लॉ लग रहा है? इंग्लिश लॉ. दिस वॉज द केस with the Indian people who were residing in the presidency towns. Now, outside the presidency towns, Regulation 4 of 1793 had provided that in suits regarding succession, inheritance, marriage, caste and all religious usages, Hindu and Mohammedan laws were to be applied by the courts, but this provision was confined in its application to Hindus and Mohammedans only. For other categories of persons and other types of suits, no specific rules of guidance was enforced except that the judges were to act in accordance with justice, equity and good conscience. So these 3 were the only principles that they could act on the basis of. आपको जस्टिस प्रोवाइड करना है, आपको इक्वालिटी करनी है, आपको लॉ क्या है वो देखना है. कौन सा लॉ? इंग्लिश लॉ. और एक अच्छे मन से, एक गुड कॉन्साइंस से आपको अपना जो भी जजमेंट है वो डिलीवर करना है. लेकिन आउटसाइड द प्रेसिडेंसी टाउन्स, इफ़ आई टॉक अबाउट द सिचुएशन ऑफ, तो वहाँ पर अकॉर्डिंग टू द रेगुलेशन 4 ऑफ 1793 एक्ट, उसमें बोला गया था दैट वट एवर मैटर्स, वट एवर डिस्प्यूट, सूट इज़ अ डिस्प्यूट वेन एवर यू टेक अ मैटर इन टू अ कोर्ट, दैट इज़ नोन एज अ सूट. और यू से कि उसने मेरे ऊपर केस कर दिया, तो उसको इंग्लिश में कहते हैं सू, SUE, सू. ओके, कीपिंग दैट थिंग्स अपार्ट, सो whatever suits or whatever disputes were relating to the matters of succession, inheritance, property, marriage, caste and all such religious issues, तो वहाँ पर हिंदू एंड मोहम्मदन्स पर, सिर्फ हिंदू एंड मोहम्मदन्स पर ही उनका रिस्पेक्टिव लॉ लग सकता था, और किसी रिलीजियन के बंदे पर उनका लॉ नहीं लग सकता. सिर्फ हिंदूज़ एंड मोहम्मदन्स को ही एक ये फ्रीडम थी कि इन सब जो मैटर्स दिए हुए हैं, सक्सेशन, इनहेरिटेंस, मैरिज, इन सब मैटर्स पर आप अपना पर्सनल रिलीजियस लॉ को अप्लाई कर सकते हैं. लेकिन हिंदू एंड मोहम्मदन कम्युनिटी के अलावा ऐसा फ्रीडम किसी और को भी नहीं दिया गया था. And the main thing was the judges have to act in accordance with these 3 principles. However, the application of laws as aforesaid created difficulties. Population of India, even outside the presidency towns, could no longer be regarded as consisting of Hindus and Mohammedans alone, because by that time it is around 1800 period. By that time, various other religious communities have also entered India and resided over here. So there were various other religions and cultures also, except from Hindus and Mohammedans. Mohammedans means Muslims or Islamic people. Besides British subjects, aliens had settled down in India. A new class of Anglo-Indians had come up. So besides British people, now it may happen कि Britishers के बच्चे हुए तो वो भी इंडिया में ही रह रहे हैं. So that is British subject. Hindus और Muslims थे और अब एक नई community आ गई थी, Anglo-Indians. The number of Indian Christians was also on increase. So Indian people, see, Britishers were Christians, but if there is a British person who married an Indian girl, so it may happen that now Indian girl is also someone who will belong to the Christian religion only. And if their child is born, so यहाँ पर a person who is born in India is considered to be of the nationality Indian. Right? A person born in India is said to carry the nationality of India. He's said to be an Indian. So he is an Indian because he is born in India, and he is of the religion Christian because his father was Christian. Right? So now he is what? Indian Christian. So now the population of Indian Christian was also increasing day by day. On account of their mixed ancestry and abandonment of their old moorings, the Anglo-Indians and Christians could not rely upon their personal laws, and even if they could, in some cases the difficulty of ascertaining their personal laws deterred the judges from applying them. So now you see, there were various religions. Every religion has its own personal or religious text. Every religion asks some people who follow it, obviously, to obey some principles, to obey some rules, right? कि if you are belonging to Hindu religion, तो ये culture, ये traditions हैं जो कि आपको follow करनी चाहिए as a part of being a Hindu man or a Hindu woman, whatever, right? So हर इसी तरीके से हर रिलीजन का एक अपना रिलीजियस टेक्स्ट होता है, अपनी रिलीजियस बुक होती हैं दैट एवरीबडी नोज अबाउट, और उसमें कहा जाता है कि ये हमारा रिलीजन कहता है, हमें ये सब चीज़ें करने की ज़रूरत है. हमारा रिलीजन के हिसाब से ये सब फेस्टिवल्स हैं, ये सब कल्चर्स हैं, ये सब ट्रेडिशंस हैं दैट obviously vary from religion to religion, right? So the Christians, Anglo-Indians, Indian Christians, Muslims, Hindus, and many more communities were there that were residing in India. India from time immemorial is said to be a land of diversities, where various different religious communities or cultural communities reside. So it was not really easy to deal with personal law of every person. अच्छा तुम हिंदू हो, ओ तो तुम पर तो हिंदू लॉ लगेगा. अरे क्रिश्चियन, हिंदू और क्रिश्चियन के बीच में लड़ाई, अब इस पर हम कौन सा लॉ लगाएं? सो देयर वॉज अ डिफ़िकल्टी, क्योंकि इतना मिसमैच हो चुका था. एज आई गिव यू द एग्जाम्पल, अ ब्रिटिश ऑफिशियल क्रिश्चियन रिलीजन मैरिंग एन इंडियन वुमेन. सो मिक्स मैच हुआ ना. There is matching of or mixing of two religions. So every person has its own law to be applied as per the religion which he or she is following. So there was a difficulty that how could I apply different personal laws, and so there was a difficulty in front of the judges that how to interpret it and how to apply it on various different people that belonged to different religions. The courts had out of necessity to fall back upon justice or equity and rule of good conscience. Now again, आउट ऑफ नेसेसिटी उनके पास कोई चारा नहीं था. वो हर चीज़ पर्सनल लॉ के साथ डील नहीं कर सकते थे. हर बंदे का अलग पर्सनल लॉ था, तो उसके साथ वो डील नहीं कर सकते थे. इसलिए वो वापस किस प्रिंसिपल पर आ गए? जस्टिस, इक्विटी, रूल ऑफ गुड कॉन्साइंस. This flexibility gave the judges opportunity to legislate and fill up the gaps while deciding cases. In short, the rules of English law by default became the governing law of British India. एज आई एम ऑलवेज सेइंग, कौन सा लॉ अप्लाई कर रहे थे वो? इंग्लिश लॉ. सो बाय डिफॉल्ट, आउट ऑफ नेसेसिटी, क्योंकि ईच एंड एवरी रिलीजन हैज़ इट्स ओन रूल बुक, और हर उस रिलीजन को फॉलो करना, हर उस पर्सनल लॉ को फॉलो करना प्रैक्टिकली जजेस के लिए पॉसिबल और ईजी नहीं था. इसीलिए आउट ऑफ नेसेसिटी वो कौन से लॉ को फॉलो करने लगे? इंग्लिश लॉ. और इस तरीके से एज टाइम पास्ड ग्रेजुअली, द इंग्लिश लॉ legislations or rules or principles that only by default became the governing law of the time. Charter of 1861 will be taken up in the next video.